It was a verdict that sent shockwaves through both the music industry and the legal world. On October 9th, District Judge Jeannette Vargas officially dismissed Drake's defamation lawsuit against Universal Music Group, ruling that Kendrick Lamar's incendiary lyrics in his chart-topping hit Not Like Us were protected under the First Amendment as artistic expression, not factual accusation. Welcome to celebrity rap life, where the red carpets never roll up and the spotlight never fades. The rewards are legendary. Because in celebrity rap life, every downfall can become a comeback, and every headline tells a deeper story. Hit that like button, subscribe, and turn on notifications so you don't miss a second of what's coming next. In her written decision, Judge Vargas described the case as emerging from the most infamous rap battle in modern history, capturing the tension that has defined the rivalry between two of hip-hop's biggest stars. Her ruling made one thing clear: in the courtroom, as on the microphone, context matters. Drake, whose real name is Aubrey Graham, had filed the lawsuit earlier this year, claiming that his own label, Universal Music Group, defamed him by promoting a song that painted him as a certified pedophile and a predator. Those explosive lyrics, delivered by Lamar in Not Like Us, became an anthem of cultural dominance, sparking dance challenges, remixes, and endless debate across social media platforms. But to Drake, it wasn't just art, it was character assassination. The lawsuit alleged that UMG deliberately amplified the song's reach despite knowing it contained what Drake called false and malicious statements. His attorneys argued that the record label prioritized profit and publicity over protecting its artist's reputation, allowing Lamar's accusations to spread unchecked. Judge Vargas, however, was unmoved. In her 37-page opinion, she methodically dismantled Drake's arguments, grounding her decision in decades of legal precedent protecting artistic and rhetorical speech. The judge noted that the contested lyrics were part of a long-standing cultural tradition. The diss track, a form of musical combat where exaggeration and provocation are not just expected but celebrated. Listeners, she wrote, would not reasonably interpret the language of Not Like Us as conveying literal fact. In the context of a competitive artistic exchange filled with profanity, metaphor, and bravado, the statements function as rhetorical hyperbole, not defamation. Her reasoning reflected a deep understanding of hip-hop as an art form, one where battles are waged with words, not weapons, and where accusations serve performance rather than truth. Drake's legal complaint positioned Not Like Us as a turning point in his public image, alleging that Lamar's lyrics fueled a narrative portraying him as morally corrupt. The rapper's lawyers cited online harassment and even threats from fans who took the lyrics literally. But the judge countered that artistic speech cannot be held to the same standards as journalism or public commentary. Defamation law protects against false statements of fact, not artistic expression, however provocative, Judge Vargas wrote. In this case, reasonable audiences would understand that the accusations were not presented as verifiable claims but as part of a cultural dialogue rooted in competition. Her decision referenced several landmark rulings, including Hustler magazine versus Falwell, where the U.S. Supreme Court held that even offensive parody enjoys constitutional protection. By linking Lamar's lyrics to that lineage of protected speech, the court signaled its unwillingness to police artistic boundaries in musical disputes. The irony was not lost on the court that Drake himself had contributed to the very cycle of provocation he later claimed victimized him. In one of his earlier diss tracks, Tailor-Made Freestyle, Drake had used an AI-generated voice of the late Tupac Shakur to taunt Lamar, mock his family, and suggest that Lamar talk about him leaking young girls. Judge Vargas quoted those lyrics directly, calling them highly relevant to understanding Lamar's response. She wrote that by invoking such themes first, Drake invited reciprocal artistic retaliation, a dynamic well recognized in the conventions of hip-hop rivalry. When Lamar fired back in Not Like Us, with the line, "Say, Drake, I hear you like M. Young," it was, in the court's view, a predictable escalation in a lyrical feud, not an evidentiary claim. For legal scholars, the ruling may prove pivotal in shaping how courts interpret artistic speech in the streaming era, where viral music moments blur lines between entertainment, commentary, and reputation. Dr. Rachel Vaughn, a professor of media law at NYU, said the decision reinforces a crucial boundary between creative exaggeration and actionable defamation. She explained that while Drake may have suffered reputational damage, the law doesn't offer remedies for hurt pride in a battle of lyrics. That point may sting for the Canadian superstar. Not Like Us didn't just dominate the charts, it became a cultural weapon. The single topped the Billboard Hot 100 for 10 consecutive weeks, won 5 Grammy Awards, and anchored Kendrick Lamar's triumphant Super Bowl halftime performance in early 2025. For months, the phrase, "they not like us," was more than a lyric. It was a declaration of artistic superiority. Drake's lawsuit, filed in January, sought damages from both Universal Music Group and its subsidiary Interscope, accusing the companies of profiting from defamation and a reckless disregard for the truth. His legal team argued that as his label, UMG owed him a duty of care not to promote content that portrayed him as a criminal. But UMG countered that it had no such obligation. Its attorneys maintained that the company's role was to distribute and market its artists' creative output, not to censor or mediate artistic feuds. In court filings, UMG's counsel described the lawsuit as a dangerous overreach that, if successful, would threaten artistic freedom across genres. Judge Vargas agreed. "Record labels are not arbiters of truth," she wrote. "Their responsibility lies in supporting artistic expression, not policing it." She added that holding UMG liable for Lamar's lyrics would set a precedent that could chill creative expression across the music industry. In a statement following the ruling, a UMG spokesperson said the company was pleased with the court's affirmation of artistic freedom. The spokesperson added, "This lawsuit was an affront to every artist who has ever used music to express pain, rivalry, or critique. We remain committed to supporting both Drake and Kendrick Lamar as visionary contributors to hip-hop culture." Still, the dispute leaves open broader cultural and ethical questions. In an era where rap beefs unfold in real time and social media amplifies every bar, when does creative rivalry become personal harm? Can artists weaponize platforms to spread damaging narratives under the guise of competition? For many fans, the case highlights a paradox that has long defined hip-hop's evolution. Diss tracks thrive on confrontation and exaggeration. They build mythologies and fuel commercial success. Yet, as the genre achieves global influence, the same artistic aggression can carry real-world consequences. Legal experts point out that while Judge Vargas's ruling closes the door on Drake-specific claims, it does not eliminate all potential liability for artists. If a rapper were to assert verifiable falsehoods outside of an artistic context, say, in an interview or a social media post, the analysis could differ. But within the confines of a song, particularly one understood as a diss record, the law grants wide latitude. That distinction, though technical, underscores the cultural literacy required in modern jurisprudence. Courts must navigate not only legal precedent, but also the unwritten rules of artistic subcultures. Drake's attorneys have vowed to appeal, arguing that the ruling sets a dangerous double standard that leaves artists vulnerable to defamation under the banner of art. In a brief statement, they said they believe higher courts will recognize that creative rivalry cannot be a blanket license for reputational harm. Legal observers, however, view an appeal as an uphill battle. "The opinion is thorough, well-reasoned, and rooted in First Amendment doctrine," said constitutional attorney Marcus Eldridge. "Unless new facts emerge, I don't see a path forward for Drake." The ruling also underscores the increasingly blurred boundaries between artistry and liability in the digital age. As music content spreads instantly across platforms, context often evaporates. A bar written as metaphor can become a meme stripped of nuance, shared by millions who may not understand its cultural coding. That dynamic was central to Drake's argument, that Lamar's words transcended performance and became viral misinformation. Yet the court, in reaffirming the primacy of artistic context, placed the onus on audiences to discern entertainment from reality. For Kendrick Lamar, the decision marks both a legal and symbolic victory. His silence throughout the proceedings was consistent with his public persona, introspective, deliberate, and reluctant to engage in sensationalism. Those close to his team say he viewed the lawsuit as an inevitable byproduct of a rivalry that had already spilled beyond music. Not Like Us had already cemented its place as a generational moment, part anthem, part cultural reckoning. Now it also stands as a legal precedent, a case study in how far the law will go to protect creative speech, even when that speech cuts deep. For Drake, the dismissal is a blow not just to his case but to his image as a controlled, strategic artist. His decision to sue his own label was unprecedented among major stars, signaling a rare fracture in one of the most powerful artist-label relationships in the industry. UMG's public reaffirmation of its support for him may paper over that rift, but privately, insiders suggest tensions remain. Industry analysts believe the fallout could reshape how record companies manage artist conflicts. Some have floated the idea of content review clauses in contracts, provisions that allow artists to challenge the release or promotion of music that targets them. Others warn that such measures could amount to censorship, stifling one of hip-hop's most vital forms of expression. Either way, the Drake v. UMG decision forces a reckoning. The courtroom battle may be over, but the questions it raises, about power, accountability, and the limits of artistic freedom, are only beginning. The hip-hop landscape thrives on conflict, from the East Coast-West Coast rivalries of the 90s to today's digital-era feuds. But this case reminds us that even in an age of endless outrage, the law still draws a line between fiction and fact, performance and defamation. As Judge Vargas wrote in her closing remarks, the court does not endorse or condemn the content of Not Like Us. It merely recognizes that in this country, even the sharpest insults and the harshest criticisms, when delivered as art, are shielded by the Constitution. For the moment, that means Kendrick Lamar walks away vindicated, Drake faces an uphill legal climb, and the music industry gains a new precedent, one that enshrines the rap battle as not just cultural theater, but constitutionally protected speech. And so, in the saga of Drake versus Kendrick, the mic drops not with a verse, but with a verdict. This story is far from over, and the truth is still unfolding. I want to hear what you think. Drop your take in the comments. And if you don't want to miss the next twist, hit that like button, subscribe, and turn on notifications so you don't miss a second of what's coming next.